Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with prominent attorney Ms. Sheela Murthy to discuss the latest updates on immigration, followed by frequently asked questions related to H-1B, green card, or any immigration matter. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV News and agents are not responsible in any way for your actions. Please use the information at your own risk. For case-specific issues or concerns, please reach out to attorneys for a private consultation. You all know very well Ms. Murthy is the founder, CEO, and president of Murthy Law Firm, and she's also Harvard Law School graduate. Also, she's the one behind the famous Murthy.com website that's helping a lot of people. Before getting into the show, Ms. Murthy, could you please briefly introduce yourself?
Wonderful. Thank you so much, Ranjit, for that warm and always kind introduction. Welcome, everybody. Good afternoon or good evening to you, depending on where you are in the world. It is always an honor and pleasure for me to share information, to educate each of you and your families that are going through the immigration process, to educate and empower you so that you feel confident when you are traversing that very complicated journey of the US immigration law and processes. As many of you know, Murthy.com and Murthy Law Firm has been around for almost 30 years. Our goal, again, is to educate, empower, enlighten, and strengthen you, to support you, to guide you, and hopefully to continue to give you the encouragement and support you need, which is what Ranjit and I are doing today through this Sakshi TV program to help all of you. So we will start off, maybe Ranjit will tell us, but we will probably start off with some hot news items. Ranjit, should we get started with that?
We have a caller. Let's take the call first, and then okay, we can take it from there. Hi, Venkat. Welcome to the show. Please go ahead and ask your question.
Hey, thank you so much for opportunity. Thank you, Sheela, for all the service you're doing to the society. My name is Venkat Padala. I applied for my adjustment of status back in October. I got all my EAD, AP, everything is there. And even my biometric is done. And I came to know from USCIS that my file got moved to field office. So the question is when submitting 485, I did not submitted medicals with it. But basically I did send the medicals to National Benefit Center a month ago without RFE. So there's no clue whether it reached to my file or not. And I did not even receive RFE for medical. My case is straight EB2, straight case, 2011 March priority date. So my question is so we did file 485J along with my application. So my 140 is approved in 2013. That time I was in different title. After that I got promoted a couple of times. Now my attorney is suggesting to file one more 485J with new title, which I got maybe 3-4 years ago. So is it advisable to submit another 485J now? So does it do any help with new title listing there?
I don't know if it'll help or harm, but that's what the law requires, Venkat, because at the end of the day, remember the supplement J is meant to show what is the future job that you are going to perform once you get the green card. Remember, the entire PERM I-140 process is not about your current job, what you're doing on H-1B today, but what you will do once you get your green card approved. And so since your job has been changed 3 or 4 years ago to something different, to be on the safe side, it would probably be helpful to file the supplement J, show that the new job duties are either very same or very similar to what was mentioned on the original PERM and I-140, so that the USCIS can approve it, because then when you are called for the USCIS interview in the local office, the fact that your case has been sent to the field office is a plus and a minus. It's good that it's gone fast. The bad news is that now that it looks like you might be scheduled for a personal interview, and some field offices are taking several months, if not years, to schedule the employment-based interview for candidates. And at that time, they will ask you, get me a more recent employer letter, a job letter confirming what are your job duties. Because if at that time there isn't either an identical job or very same or similar, the USCIS can deny the case. So by filing the supplement J, you are showing that in fact it is the exact same or similar job. So I would do it because you have to, and that's what the law requires, Venkat.
Yeah, thank you so much, ma'am. I appreciate all your help. Thank you.
Great. Thank you, Venkat.
We have another caller, Shravan, from Tennessee. Hi, Shravan. Welcome to the show. Please go ahead and ask your question.
Hey, thank you, Ranjit. Hi, Sheila. Thank you so much for taking my call and all your advice. So I have a quick question regarding my situation. So I would like to take your advice from your expertise. So my current date, my priority date is like December 2012 EBT, but I wasn't able to apply in last October because I had a perm pending. Now I got my 140 approved in EB2 and everything is ready, but under EB3, my date is current, but I'm in the EB2. So what do you suggest, since it's December 12 and my priority date is in EB3 is current, do you suggest downgrading to EB3 at this time or being in the same line? And what can you please advise the best that I can do at this point?
So again, nobody knows for sure, as you can imagine, Sraval, what's going to happen with the priority dates. But in general, we expect a fair forward movement based on what Charlie Oppenheim just announced very recently. And so we do expect the date to continue to move, especially EB2. And 2012 is a very good date that you have. So we're expecting for sure both EB2 and EB3 to become current. If not for September, which has already just been announced we have now August dates have been announced, but by September for October, we at least expect it to move most likely. Again, nobody can give you a 100% guarantee. So if the date is going to become current, that way you don't have to wait for the EB3 downgrade case to get approved. You might as well just file it without waiting for the downgrade to get approved. Keep the 485 package ready, get everything ready. And the minute your date is current, and if it's moving, because it's moving quite quickly, and I think what Charlie also said was over 100,000 employment-based numbers are going to be unused going to remain unused. So they will move the date forward. Now, he's not expecting it to become current, but I think 2012 seems like a no-brainer right now. So keep your package ready. And if you can file it by next month, great. If not, then in the worst case, you can always do an EB3 downgrade after 1 or 2 months, rather than filing it with a downgrade, and then they cannot approve your 485 until the downgrade gets approved, which will waste more time and more money. And there's also risk. There's a risk when you do a downgrade, because if they find that there was an error in the original approval, they not only will not approve your EB3 downgrade, they will also try to threaten to take away the EB2 case, as I was discussing with another person who was afraid that because of some mistake in the filing, that it could actually result in losing the EB2 approval also.
Okay. So since Charlie said like 100,000 are going unused in EB2 this year, so since most of the applications are still under process, so they may account for the next year. So will that slow down any movement? Is that my worry? That's the thing I'm worried about.
So he did say that the reason the dates cannot become current, like in 2007, was because there's a huge demand. There's no shortage of number of people who can apply and want to and are waiting to file their last stage, their 485s. But your question is, could this continue or could this become worse? Could this become better? I think EB2 will continue. It will get processed. I think it may just be by October, we expect it. So if not, then just file it in EB3 downgrade, but after a month, rather than waiting right now and doing it, because then until the downgrade is approved, your 485 cannot get approved, Sramal.
Okay. That was a great advice. We have another caller from Texas. Hi, welcome to the show. Please go ahead and ask your question, Mahesh.
Hi, thanks for giving the opportunity. Hi, Sheela Murthy. So my form
Hi,
was
Mahesh.
applied on February 10th. Hi, good afternoon. My form was applied on February 10th by my employer. Right, I think it's currently with Department of Labor. So one of my friend who applied on February 25th, he got his approval. But the people who applied on February 4th or February 1st or February 10th, in my case, which is February 10th, we didn't hear any news. It still says like the analyst review. So how does the Department of Labor process this? Is it first come, first serve basis or is it a random pick in a mixed jar?
Mm-hmm. Well, it's generally first come, first serve, but also it depends on the examiner. Supposing I give you an assignment to Mahesh, to you, to Ranjit, and to myself, you may be very fast, I may be very slow. So I may take a few extra weeks or days to do something, right? And you may be extremely efficient and prompt and diligent and finish the work early. So maybe your friend who got it from September 25th had an examiner who is catching up on the work, and some other people are dealing with much slower work. So a few weeks this way and that way isn't a problem. It's only if it's years apart, then the question is there going to be a Department of Labor audit, Mahesh, or there's some other problem with the case, or are they planning to deny it because there's some incorrect errors? But few weeks this way, that way, I don't let that bother. I know for you, it'll be making you nervous, but it is not like it's a computer generated, because each Department of Labor investigator or officer is assigned a certain number of cases. And so some will move a few weeks faster than others.
Okay, I have one follow-up question, or basically another question as well. Can I ask?
Yeah, please go ahead.
Yeah. So regarding the wastage of 100,000 GCs, I sent emails to Charlie asking like what are they gonna do, because they're blaming it on COVID for all the spillover wastage and all that stuff, which is not actually. But I want to ask. I sent an email to Stinko asking like what are the steps they are gonna take to avoid the wastage of GCs in 2021, fiscal year 2022. I didn't get any answer, but as a proud immigration supporter of INA, like what can you, or like what both this forum is taking steps to avoid the spillover wastage? Like, are you guys planning to do something, or like something like to avoid wastage of the spillovers as a big immigration attorney firm, or are you guys planning to do something?
I understand. Yeah, Mahesh, I understand your question. Thank you for that. And it's a valid point. I'm guessing Charlie Oppenheim is brilliant, smart, and bright, but he's with the US Department of State, and typical federal government, right hand cannot mess with the left hand. So when you ask him, what are you going to do with spillover? Charlie Oppenheim from US Department of State has big zero to deal with wastage and usage of numbers within the United States. That is 100% within the realm and the jurisdiction of the USCIS, the US Citizenship and Immigration Services, but not with Department of State. That's with Department of Homeland Security, because USCIS is part of DHS and not Department of State or DOS. So Charlie cannot answer that question, because who is responsible for processing 485 cases within the United States? It is only USCIS and not Department of State. Now, Department of State is involved or responsible for processing of immigrant visa numbers with US consulates around the world. And that 100% has been impacted by COVID-19. So when Charlie is explaining that part of the reason that we're losing it is because of COVID-19, that is true, because US is not impacted as much now, was 1 year back. But around the world, for example, Indonesia or India or other countries, where because of COVID-19, the consular officers aren't working, aren't able to process cases, they have put things on hold. They're only dealing with emergencies or family-based cases, giving top priority. That's what the Department of State can deal with, backlogs at US consular posts around the world. But USCIS has to process 485s, and they do more than 90% or 95% of usage of employment-based cases. In fact, I think almost 99% of employment-based cases are processed by USCIS within the United States. So if it is up to USCIS to process and not ensure that they get wasted. And you can try to sue them, you can file a lawsuit, you can file a writ of mandamus for delays, etc. But we've been seeing USCIS has been playing all kinds of games, especially under the prior administration, which was purposefully trying their best to delay approving so that we all would suffer. But now I think the Biden administration has changed their policies, have become much more diligent, is making things better for immigrants, and they want to process much faster. But to some extent, if COVID continues because of the third wave, because of people choosing not to get vaccinated that are bringing back the COVID in the country, it could end up resulting in a third wave in the United States, causing delays because in the US. But yes, hopefully USCIS will continue promptly to process. In fact, we just had a meeting last week with USCIS local offices, both in Washington, D.C., I think is next week, and Baltimore and other parts of the country. And they had 80,000 cases backlogged in processing citizenship and 485 interviews. Now it is hardly 3,000 or 4,000 cases that are remaining. So every local office is trying to eliminate the backlogs and trying to move things along, Mahesh. What you can do and what we can do is sue them. If they're wrong, if they're taking too long on your particular case, when your priority date becomes current, then you can definitely sue the government if it's past the 6 months processing time, which is the expected average processing time supposed to be for 485s according to the USCIS average expected processing of 485 cases.
Thanks, Ms. Murthy. Thanks for your detailed explanation. We have another caller, Rao from Ohio. Let's take the call. Hi, Rao. Welcome to the show. Please go ahead and ask your question.
Hi. Hi, Ms. Murthy. Thank you for taking my call. I have two questions. One question is about my brother who is in India. He's got his 140 approved, but his 140 was withdrawn after 6 months. So if he wants to come back to US, does he have to go through this 140 filing again and H1 or just the H1?
So if he goes back to the same employer, he will need a new, and even with a new employer, but he can get a 3-year H1 extension based on the I-140 approval being valid for over 180 days, Rao. He's allowed to get a 3-year H1 extension filed by any new employer to come in and work. But if his green card has to start, each time you change a job or change an employer, the entire perm I-140, 485 has to start from scratch. The only thing he may be able to carry or move is, of course, he can transfer or port the earlier priority date based on his prior approval.
Okay. So I understand that if he's going to the same employer, he just needs the H1 filed and then he should be good. Is that right?
No, he'll need the H1 because they revoked the I-140. They'll have to file an I-140 for him because they revoked it. With a new employer, he has to start with a fresh perm and I-140, 485. With the same employer, because they revoked the I-140, they will have to refile that I-140, do a fresh H1, bring him, and then file the I-140. And if the priority date is current for him in his approved, based on the EB2 or EB3 category, then he can file the 485 concurrently or simultaneously with the I-140 filing, because once you withdraw it, there is no underlying I-140 left for that same, even the same employer. They have to refile a fresh I-140 for him.
Thanks, Ms. Murthy. We have another caller, Pradeep. Hi, Pradeep. Welcome to the show. Please go ahead and ask your question.
Maybe we lost Pradeep.
Okay. Yeah, Ms. Murthy, can we just go with the Charlie Oppenheim updates and the other update regarding the F1 that USCIS just announced to resend the policy?
Yes, thank you so much, Ranjit. Absolutely. So we've already gone over some of the highlights from what Charlie Oppenheim just announced with the US Department of State. You have access to his interview and tape, but basically there are about 100,000 unused immigrant visa numbers in the employment-based category. They expect dates to keep moving forward. They don't expect any drastic change in the dates, for example, becoming current like back in 2007. Usually in October each year, USCIS allows the date of filing, not just the final action date as in the rest of the year, for people to file which might help like last year, October of 2020. We're hoping the dates will move a little bit more so that a lot more people can file the 485s this year. And Charlie basically talked about, Department of State and their backlogs and their policies and what's going on. The other hot news that what Ranjit just mentioned was that USCIS just today, a couple hours ago, I believe, on July 20th of 2021, issued a memorandum clarifying that those who are filing a change of status to F1 no longer need to keep on filing B2 extensions of status bridge. For example, if they're switching from H4 to F1, before they had to keep on paying fees every 6 months because of the slow processing of USCIS and pay hundreds and hundreds of dollars each time to be the bridge status. Now the USCIS is saying they're going back to the pre-Trump policies of allowing the person who was on a valid H4 status, for example, to stay legally in the United States and file the change to F1, but not have to waste the money or wait for the bridge approvals, because that was really like a scam. If you or I did that, we would be in jail for committing theft and fraud, because it really was like their laziness and their incompetence and their inability to process was resulting in hardworking, good, honest families spending hundreds, if not thousands of dollars for month after month, year after year of delays by USCIS in approving the change of status to F1. So it was almost like rewarding bad behavior. Luckily, that policy has now been removed. As long as you were in status when you filed the change of status to F1, you're allowed to stay here, start attending classes if you're on H1B, and you don't have to keep on spending more and more money filing this bridge status to B2, paying thousands of dollars, hundreds of dollars for each extension and doing it 2 or 3 times in some cases.
Thanks, Ms. Murthy. Thanks for all the updates. We have a caller, Janardhan from India. Let's take the call. Hi, Janardhan. Welcome to the show. Please go ahead and ask your question.
Yeah. Hello. Hello, ma'am. Thanks for your time. This is Janardhan. So I have a question regarding my H1B stamping. So I was picked in the lottery and I got my visa issued in 2019 through my current employer, and I got my visa stamped. Now, I didn't get the chance to travel to US since I got my visa stamped. Now, I'm having an offer from an employer who is willing to do an amendment and new petition. And then, so will I be able to use my existing visa stamp, or should I have to go for a new stamping again?
No. Janardhan, you can use your, Janardhan, the law allows you to use your prior H1B visa stamped in your passport, along with showing when you enter the country, you have to show USCIS the latest H1B approval. So if you got stamping with employer A, you have to show the H1B petition approval with employer B, and ensure that your online I-94 card shows that it is valid until the date of your latest H1B approval notice. So for example, if back in 2019, you had a 3-year H1 approval till 2022, you can use that visa stamp in your passport to enter the country. But let's say a new employer files now 2021 until 2024, you should get I-94 card, your online I-94 should be valid until 2024, the date of your latest H1B approval notice, which is it is your obligation and responsibility to show that to the US Customs and Border Protection at the airport when you land, to ensure that they approve it, not based on the prior approval notice, but only using the past visa stamp, latest H1 approval notice, ensuring you get the correct I-94 card online through the CBP to ensure that you're okay. But it's your responsibility to show that latest H1B approval notice. Some people think, no, I can't show them, it'll confuse CBP. No, if you don't show it, then it's going to be a problem, because you will only be allowed to work for 1 year in the United States. And again, your employer has to spend thousands and thousands of dollars filing the extension for you, right? Hope that was helpful.
Yeah, thanks, Murthy. Thanks for your great advice. We have the caller Rao again. He wants to ask another question. Hi Rao, welcome to the show. Please go ahead again and ask your question.
Hi, ma'am. Thanks for taking the call again. My question is, I've downgraded from my EB2 to EB3, and my final action date is current in the July bulletin. I have my son who is 18 years of age, so I'm wondering if I can convert my EB3 to premium because my EB2 was approved at the same service center where my EB3 is lying right now.
Okay, well, you certainly could, but remember, Rao, it's not for USCIS. The law for children aging out is not 18 years. Many people get confused and think it is 18 years. So it is actually 21 years of age for the child. So your child is protected by law. If the final action date is now current and your 485 is filed, your child's age should be frozen under the CSPA, Child Status Protection Act formula. So you can certainly spend the money to file and request the USCIS to approve your case under the premium processing program. But even if they approve your I-140 under premium processing, Rao, there is no 100% guarantee that they will approve your 485 because there is no premium processing available for 485. So if it gives you peace of mind, get that taken care of. But again, the 485, they will process it, and the child still has 3 full years before the child is considered to lose the benefit as your derivative beneficiary under your green card approval.
Thanks, Ms. Murthy. Thanks for your advice. We are towards the end of the show. Again, it was a great show. Thanks, Ms. Murthy. Thanks for all your time and advice. Again, thanks for all the callers for watching the show. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. Again, it's every Tuesday, 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Bye-bye, Ms.
Thank
Murthy.
you all. Bye-bye.